In fact, not only can you, you are required to. You cannot pick and choose in this game. Now, it may be that you're not going to be making payments on a secured debt in the plan. Maybe you're going to be paying them directly to the creditor as opposed to having conduit payments going through the Chapter 13 trustee. But you do not get to pick and choose. In fact, when you sign your petition and you attend the meeting of creditors and swear under penalty of perjury, one of the things you're swearing to is that you have listed all of your creditors, both secured and unsecured. And if you haven't done so, you've committed perjury. And there is the potential for a stay at taxpayer expense in a federal penitentiary. Now, I will say that does have a silver lining because it's a federal penitentiary as opposed to a state penitentiary. I've never actually been in a penitentiary. I've never taken a criminal case, but I have had some clients who were bankruptcy clients who, prior to becoming my clients, had in some cases spent years in penitentiaries, and they did assure me that the food was better in the federal penitentiaries. But I'm willing to take their word for it, and if you become my client, I hope you'll take their word for it, and we'll just have you list all of your creditors, both secured and unsecured, and we won't have that problem. Now, the way those debts are treated in the Chapter 13 is not necessarily the same, because after all, secured creditors have rights attached to the collateral securing their claims. Unsecured creditors don't. And in the realm of unsecured debts, Congress, in its extremely finite wisdom, has seen fit to give some unsecured debts better treatment than others. Those are what are called priority unsecured debts. So in a Chapter 13, frequently payments on secured debts are out of the plan. They're still disclosed, and that's part of your ongoing living expenses that we list, but you don't make those payments directly to the trustee. On the other hand, if you have an arrearage, a pre-petition arrearage, that pre-petition arrearage will be paid through the plan, and some trustees will say if it's a large enough arrearage, you're not trustworthy, they will insist on conduit payments. Secured debts, then, are not treated quite the same way as the unsecured debts. Unsecured debts, they all go through the plan. The priority unsecured debts must be paid in full through the plan unless the creditor accepts different treatment. The unsecured non-priority debts are just paid at whatever rate you can afford, provided your plan satisfies the main requirements of a Chapter 13 plan. But long and short of it is, you have to list everybody. And, you know, if you just think it through, it's a matter of fairness. Let's say, for argument's sake, you were a creditor, and there's Charlie, and he lists your debt in his bankruptcy case, and then there's Jim down the street who's also a creditor, and he doesn't list Jim. What are you going to say? Hey, that's not fair. How come Jim gets paid in full and I don't? So it's really a matter of fairness as well as, well, this is what the law requires.